he's a predator, and all predators do whatever they can to get what they need.
You know the anger I hear when I can keep it together and did not feel like the other people who's way older than me can't? That makes me want to beat somebody's ass. And I'm getting to the point to where I want to fuck some people up. And I'm sorry y'all hearing this, but I know. Next motherfucker that don't stay straight and my life is on the line and you eating in my motherfucking house and you're living off of my motherfucking information, my word, you will be excommunicado and I will kick you out of the place that I am dwelling. I guarantee you, I am done with the mess. So if you guys can't get together, please today leave the embassy and never fucking return. Because you guys are getting on my motherfucking nerves. Do you get that? You just not have to be thinking about my life with all the information that I have and all the things that I've set forth for all of you to get done, for you guys to live a lifestyle, for you FCC, you to rent a home, for you to be out of a truck. And this is a thank you. I am so disgusted. I am telling y'all, if my family get hurt because you two can't stay together and focus, I guarantee you it won't be a nice, pretty job of both of you motherfuckers. Call it a threat. I don't give a fuck. You guys are jeopardizing my family's life with your attitudes. So if you guys can't get together, guarantee you I will have another plan to deal with everybody who do not do their fucking part that got me into this shit. Do we have an understanding?
Yes.
I got 30 fucking kids. Fuck y'all. Y'all better get this shit together. I'm staying focused. I'm writing all these fucking things. I'm putting all this shit together. And this is the fucking thing. I swear to the motherfucking creator. Y'all think y'all talking about spiritual? I'll show you some spiritual shit to be wrapped up in a fucking blanket and it will come to your motherfucking house. Do not fuck with me. I am tired of this shit. So I'm telling you, y'all better get this together and keep this shit from my fucking house. And by Shane, if you can't get it together, take your ass to that other place. But I'm tired of it.
I'm talking about traumatizing narcissists because I'm making it a little different. And I want to describe a relationship, not just a particular kind of person. And I want to talk about what happens in that relationship. And what I'm saying is that in a cult, a leader who's a narcissist traumatizes her followers. And what is the trauma? The trauma is the trauma of subjugation. But I also base my formulations on many years of working with adult children and extremely narcissistic parents. The cult leader is what I call a traumatizing narcissist. Narcissism today is a public word in common parlance. And when most people talk about narcissism, they are referring to a self-centered, vain, exhibitionistic people who seek admiration and make everything about themselves. And there's an amazing amount of popular psychology about narcissism. It's all over the internet. And there's just an absolute ton of it, how to divorce one, how to get one out of your life, how to deal with one who's a boss, and so on. But the psychoanalytic definition of pathological narcissism is a little more complicated. It's too complicated. In fact, it's so complicated, I'm going to pause, and monitors are going to hand out 2 Excedrin and an Adderall. And since we're in Santa Fe, a shot of tequila.
So it's a very, very unhealthy type of person to try to have a relationship with. And it's further worsened because they will gaslight everyone into thinking that it's everyone else's fault that they can't have normal relationships when they are constantly engaging in narcissistic abusive behavior. So very often what we'll see is that they will conveniently adopt philosophies that downplay the value of taking personal responsibility and apologizing to other people. In fact, they will try and flip it and make it seem like apologizing is somehow a vice. And that, of course, preserves their toddler worldview. And so the thing to keep in mind when dealing with narcissistic predators like this is you are dealing with a child and they're doing harm and they're getting people killed and they are still in the mentality of a toddler about it all. So the pathological cult leader or the bravado toddler male needs agreeable people beneath him to support him because he is essentially psychologically a toddler. Then he surrounds himself by essentially caregivers. He's just padded himself by an army of mothers who are going to just love him and support him and go along with whatever he wants. And then when he doesn't get his way, it's the same psychology as a child berating its mother. You know, well, why didn't you just give me this? Why aren't you loving me? Why aren't you doing what I want? Why? You should give me everything. Give me all of your money, all of your time, all of your attention. It needs to go to me, 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 me. And what's so deeply ironic about this is these toddler bravados are the very ones that will position themselves as the experts on life. How can you teach me about adulthood when you are a toddler? And because they spend their entire life living off of impulsive decision making, they fail to consider that they're going to wake up one day and be 55. And they're going to be wondering where their grandkids are, why their children don't come to see them. It furthers the isolation of the cult leader as well as the cult followers, and leads them both into the eventual pathological isolation and an emotional roller coaster. So it's an abusive cycle, no doubt about it. And so the way you would describe this in archetype language is that this is the jealous moon. This is the man who's jealous of the sun. And so he's trying to position himself as the sun. I'm the sun. I'm the sun. All the legends of the sun were based on me, so give me the attention. He'll surround himself by highly agreeable men and women who will just go along with whatever he wants, and his behind-the-scenes friends will just go along with whatever he wants as well. And so you can just write it out as a mathematical formula that will lead to mental collapse. So the irony is, if there was ever a man who was set down to be a false messiah, that would be the formula you would predict, is someone who says, I was the messiah, and all the legends are based on me, and I'm going to give you an example of that. And what they're actually doing is giving the perfect example of the moon, and giving a perfect example of what happens when you let the moon become your sun, and it ends bad. It ends in chaos. It ends in death. People die, and the delusional moon is like, oh, well, yeah, I had nothing to do with that, folks. Look over there. Look over there. Ooh, poof, look. Poof, poof, poof. Shabam.
This is the reason why humanity was a mistake.
November 20th, 2020. Hassa ELBY, plaintiff, via Conrad Dominguez, et al., defendants. Hassa El Bay, Las Vegas, Nevada, pro se. Matthew J. Kaczmarek, United States District Judge. Hassa El Bay, Las Vegas, Nevada, pro se. Order. Matthew J. Kaczmarek, United States District Judge. This matter comes before the court on 6 motions. 1. Motion to dismiss of the State of Texas, filed June 12, 2020, ECF number 10. 2. Motions to dismiss of the Office of the Attorney General of Texas and Ken Paxton, filed June 12, 2020, ECF number 11. 3. Motion to dismiss of the State of Texas, filed June 4, 2020, ECF number 41. 4. Motions to dismiss of the Texas Department of Public Safety, Texas Highway Patrol, Philip Ayala and Susie Whittington, filed June 5, 2020, ECF number 7. 5. Motions to dismiss of the Texas Department of Public Safety, Texas Highway Patrol, Philip Ayala and Susie Whittington, filed June 12, 2020, ECF number 42, and 6. Motions to dismiss of the Office of the Attorney General of Texas and Ken Paxton, filed June 12, 2020, ECF number 43. For the reasons below, the court grants the 6 motions to dismiss. Background. In 2019, a patrolman stopped plaintiffs Hassa El Bay and Elyam El Bay for speeding in because passenger Hassa El Bay was not wearing a seatbelt. See complaint paragraphs 9 through 11, at 2 to 3. The patrolman asserted he smelled marijuana in the vehicle while investigating the traffic violation and therefore suspected the car contained illegal drugs. See ECF number 19, at 20. The patrolman and 2 backup officers searched the car without plaintiff's consent or a warrant. See complaint paragraph 14, at 3, ID. Paragraph 16, at 3, ECF number 19, at 24. When the patrolman and backup officers allegedly found more than a pound of marijuana in the vehicle, they arrested plaintiffs for possession of marijuana and for providing a false name to law enforcement. See ECF number 19, at 24 to 26. The patrolman who initiated the traffic stop asserts plaintiff Hassa El Bay resisted arrest and was subdued. See ECF number 19, at 20, which plaintiffs aver involved holding plaintiff Hassa El Bay at gunpoint. See, e.g., complaint paragraph 15, at 3. Plaintiffs also contend they were not read their Miranda rights. See complaint paragraph 40, at 5. The plaintiffs were then photographed and fingerprinted without their consent, giving rise to plaintiffs' arguments that their likenesses are in jeopardy. See complaint paragraphs 43 through 44, at 5, paragraph 48, at 5. Hassa El Bay is the fictitious name plaintiff Andre Pierre Harris provided officers at the time of his arrest and under which he filed his motions. Curiously, he disputes existence of the alias in multiple documents he filed and signed under that alias. The court need not resolve this oddity, as no party asserts any person suffers mistaken identity. Instead, the court refers to plaintiff by the name captioned in his complaint, filed March 24, 2020, ECF number 3. Plaintiffs initially filed separate cases, which the United States magistrate judge assigned to this case consolidated on August 7, 2020 because they involve a common question of law or fact, Federal Civ EP 42, A2, and would not prejudice plaintiffs, see ECF number 40, at 3. Plaintiffs' individual complaints are nearly carbon copies. Wherever no difference in wording, paragraphing, or pagination distinguishes plaintiffs' claims from each other, the court for the sake of clarity refers to and cites the 2 complaints collectively as complaint. Because plaintiffs were booked late in the afternoon, they remained in jail until their probable cause and bail hearing the following morning. See complaint paragraph 50, at 6, ECF number 19, at 20, ID. At 26. Plaintiffs were advised of their Miranda rights during the hearing and acknowledged via signature they had been informed of those rights and the charges against them. See ECF number 19, at 26. Bail was set for each plaintiff at $15,000, an amount plaintiffs maintain they subsequently negotiated down to $10,000 combined and paid under duress in opposition to such extortion. Complaint paragraphs 62 through 67, at 7. Plaintiffs each filed Section 1983 suits in this court on the same day against the same 29 government defendants, arguing that said defendants were variously involved in the traffic stop, booking process, or hearing. In April, the court referred the case to the United States Magistrate Judge based in the Amarillo Division. See ECF number 5. When said magistrate judge recused, the court referred the case for pretrial management to the magistrate judge in the nearby Lubbock Division. See ECF number 23. That magistrate judge consolidated plaintiffs' cases in August. See ECF number 40. Plaintiffs objected to the referral on the theory the undersigned judge is not their registered owner. ECF number 6 paragraph 4, at 2. But the referral is permissible under 28 U.S.C. section 636, B, 1, A, and Rule 72 of the Federal Rules of Civil Procedure. Plaintiffs each subsequently filed motions indicating they accepted the magistrate judge's consolidation order, but only on the condition that he, 1, provide them with the original copy of his appointment letter, 2, order the arrest of all defendants and defense counsel, and 3, enter default judgment against all defendants. See ECF number 59 paragraphs 1 through 2, at 2 to 3, ECF number 61 paragraphs 1 through 2, at 2 to 3. Plaintiffs imposed a deadline for these actions 3 days after their motions were filed. See ECF number 59 paragraph 1, at 2, ECF number 61 paragraph 1, at 2. Plaintiffs seem to misunderstand the nature of a consolidation order under Rule 42 of the Federal Rules of Civil Procedure. The court is given broad discretion to decide whether to consolidate cases under this rule, and the consent of the parties is not required. See 9A Charles A. Wright and Arthur R. Miller, Federal Prac. And Processive Section 2383, 3D Edition 2020. Plaintiffs' acceptance of consolidation is therefore appreciated but not necessary, and the conditions plaintiffs place on that acceptance have no legal effect. Plaintiffs allege multiple constitutional claims against the 7 defendants who are the subject of this order. 1. The State of Texas. 2. Texas Attorney General's Office. 3. Paxton. 4. Texas Department of Public Safety, TDPS. 5. Texas Highway Patrol, THP. 6. Ayala. And 7. Whittington. First, they allege all defendants engaged in a warrantless vehicle search in violation of the Fourth Amendment. See complaint paragraphs 28 through 35, at 4. Second, they contend all defendants arrested them without Mirandizing them, violated their privacy, and committed trespass against their persons in violation of the Fifth Amendment. ID paragraphs 36 through 48, at 5 to 6. Third, they maintain all defendants conspired to jail them without notice of their offense, deprive them of counsel, and violate their right to a speedy trial under the Sixth Amendment. See ID. Paragraphs 49 through 59, at 6 to 7. Lastly, they aver all defendants set excessive bail in violation of the Eighth Amendment. See ID. Paragraphs 60 through 69, at 7 to 8. Defendants all claim immunity from plaintiff's suit. The 4 defendants that are state entities, the State of Texas, Texas Attorney General's Office, TDPS, and THP, and defendant Paxton in his official capacity as State Attorney General argue that they enjoy unwaived sovereign immunity under the 11th Amendment. See ECF number 7, at 2 to 3, ECF number 10, at 1 to 2, ECF number 11, at 2 to 4, ECF number 41, at 1 to 2, ECF number 42, at 2 to 3, ECF number 43, at 2 to 4. Defendants Paxton in his individual capacity, Ayala, and Whittington aver that Section 1983 liability does not attach via respondeat superior absent proof of official policy or custom. See ECF number 7, at 3, ECF number 11, at 3 to 4, ECF number 42, at 3, ECF number 43, at 3 to 4. All 7 defendants therefore ask the court to dismiss plaintiffs' claims against them under Rules 12, B1, and 12, B6, of the Federal Rules of Civil Procedure. Legal Standard. Section 1983 Suits and Immunities. The text of 42 U.S.C. Section 1983 holds liable to suit every state official who violates an American citizen or resident's rights under color of law. 42 U.S.C. Section 1983. Congress created the remedy shortly after the Civil War to counter endemic official action in the South that deprived freed slaves of their rights, and bill sponsors therefore intended for the remedy to be construed liberally. Cong. Globe, 42 Cong, First Session App 68, 18. Claims dismissed against state entities and defendant Paxton in official capacity under Rule 12, B1, and Rule 12, B6. At the motion to dismiss stage, the court must accept plaintiff's allegations as true. See Dyer, 964 F.3d at 379. But even an extraordinarily generous reading of plaintiff's complaint does not identify anywhere they specifically challenge any action, inaction, or policy of the state entity defendants or defendant Paxton in his official capacity. The court therefore dismisses the action against them under Rule 12, B6, for failure to state a claim on which relief can be granted. Even if plaintiffs made particularized allegations against the state entity defendants, they all enjoy unwaived sovereign immunity here qua state entities. The State of Texas and Texas Attorney General's Office fall squarely within even the narrowest parameters the Supreme Court has imposed on the 11th Amendment since 1796. See 13 Charles A. Wright and Arthur Ark Miller, Fed. PRAC. And Proc Juris. Section 3524.2, 3D edition 2020. In the face of circuit splits, the Fifth Circuit has held highway authorities and law enforcement agencies also are state entities for 11th Amendment purposes. See Oliver v. Scott, 276 F.3D 736, 742, 5th Circle 2002, Fireman's Fund Insurance Company v. Department of Trans and Development, State of Law, 792 F.2D 1373, 5th Circle 1986. Because, 1, the 11th Amendment sets the floor of sovereign immunity and, 2, sovereignty immunity is a jurisdictional bar in this circuit, the court therefore also must dismiss the claims against the state entity defendants under Rule 12, b. 1. So too with defendant Paxton in his official capacity because the ex parte Young exception manifestly does not apply here. Plaintiffs challenge, 1, a state law defendant Paxton allegedly, 2, did enforce at a time in the past and the enforcement of which is, 3, not ongoing. 3 strikes might be increasingly acceptable in modern sabermetric baseball, but they continue to defeat ex parte Young arguments in federal court. The court accordingly dismisses plaintiff's action against defendant Paxton in his official capacity under Rule 12, b. 1. B. Claims against defendant Paxton in his individual capacity and defendants Ayala and Whittington dismissed under Rule 12, b. 6. At the motion to dismiss stage, the court also must accept plaintiff's allegations against the individual defendants as true. See Dyer, 964 F.3d at 379. Squint as intently at plaintiff's pleadings as it can, the court discerns no specific allegations plaintiffs make that these defendants directly infringed their constitutional rights. The court therefore understands plaintiffs to make claims against these defendants exclusively in their supervisory capacity. In Section 1983 suits, government officials are not categorically liable for unconstitutional conduct or omissions of their subordinates on a theory of vicarious liability. Iqbal, 556 U.S. at 676, 129 S.CT 1937, Alderson, 848 F.3d at 419-20. Only 2 exceptions to this default rule exist, namely, if a supervising official either implemented an unconstitutional policy that directly resulted in a plaintiff's injury or failed to properly train a subordinate employee. See Pena, 879 F.3d at 620, Tompkins, 828 F.2d at 303-04. Plaintiff's allegations relate only to a single isolated incident, but without allegations of a recurring pattern, a claim based on custom or policy must fail. See Petrowski v. City of Houston, 237 F.3d 567, 581, 5th Circle 2001, Bennett v. City of Slidell, 728 F.2d 762, 768 N.3, 5th Circle 1984. Plaintiff's claims thus are not well pleaded under the Fifth Circuit's checklist approach to Iqbal plausibility analysis. See Patrick, 681 F.3d at 616. The court dismisses all claims against defendant Paxton in his individual capacity and defendants Ayala and Whittington under Rule 12, b. 6. In sum, the court grants all 6 motions to dismiss it enumerated on page 1 of this order, namely, 1. Motion to dismiss of the State of Texas, filed June 12, 2020, ECF No. 10. 2. Motions to dismiss of the Office of the Attorney General of Texas and Ken Paxton, filed June 12, 2020, ECF number 11. 3. Motion to dismiss of the State of Texas, filed June 4, 2020, ECF number 41. 4. Motions to dismiss of the Texas Department of Public Safety, Texas Highway Patrol, Philip Ayala and Susie Whittington, filed June 5, 2020, ECF number 7. 5. Motions to dismiss of the Texas Department of Public Safety, Texas Highway Patrol, Philip Ayala and Susie Whittington, filed June 12, 2020, ECF number 42, and 6. Motions to dismiss of the Office of the Attorney General of Texas and Ken Paxton, filed June 12, 2020, ECF number 43. Lastly, this order terminates all outstanding motions related exclusively to the State of Texas, Texas Attorney General's Office, the Texas Department of Public Safety, the Texas Highway Patrol, Attorney General Paxton, Ayala, and Whittington, or to any combination of case defendants solely consisting of any of the foregoing defendants and other defendants already dismissed from this case. Namely, ECF numbers 7, 10, 11, 16, 41, 42, 43, 45 are terminated. So ordered.